Right now on the Daily Debrief, jury selection is set to begin in the case of a Florida man who gunned down an African-American in a parking lot. Does the video show a crime or self-defense? And the Florida defendant who beat a murder charge after he admitted to carving up his father's body might now have to pay. Plus, 2 new civil suits against a millionaire pedophile who apparently killed himself in prison. And federal prosecutors face sanctions for snooping in on phone calls between defendants and attorneys. The Daily Debrief recaps the day in court. It's Friday, August 16th. Welcome to the Debrief, everybody. Glad you're with us this evening. We have a lot to talk about tonight. We're going to start with breaking news off the top. The New York City Medical Examiner's Office has officially ruled the death of millionaire pedophile Jeffrey Epstein as suicide. The autopsy report says Epstein hung himself in his jail cell this past weekend. Also today, Epstein's estate being sued by 2 new plaintiffs today who claim they were the victims of his sex abuse. The accusers say in court documents that they were aspiring models working at a New York coffee shop when one of Epstein's alleged enablers approached them. One of the plaintiffs says she was offered hundreds of dollars, with the accused enabler allegedly saying that her nice, wealthy client liked young, pretty girls to massage him. After going with that alleged enabler to a club, the accusers accepted the offer because they said they were struggling financially. And now, jury selection beginning Monday in the case of a Florida man who shot and killed another over a fight in a parking lot. Michael Drejka is accused of manslaughter with a firearm after he gunned down Marquise McLaughlin. Prosecutors say Drejka confronted the victim's girlfriend for parking in a handicapped space, without a permit. The victim pushed Drejka, so Drejka pulled out his gun. He has a permit and was legally allowed to carry. From there, Drejka says the victim made a twitch, so he fired and claimed self-defense. Now, at first, police agreed with the defendant that this was self-defense, but they changed their mind and he was eventually charged. At the center of this case is surveillance footage of the shooting. The video recorded in the parking lot where the shooting occurred shows the defendant, Michael Drejka, presumably pointing out the handicapped parking spot where victim Marquise McLaughlin's girlfriend had parked. Then the victim emerges from the store, hurries to the defendant, and shoves him. The defendant, from the ground, pulls his weapon and fires. McLaughlin, injured, runs back into the store. Was it self-defense or a criminal act? New York Law School professor and former NYPD detective Kirk Burkhalter analyzed the recording for Law&Crime.
Now, a key point here is that once the defendant drew his weapon, the victim took one step back. So if you freeze that moment in time, the threat was over. Theoretically.
Burkhalter notes that in some states, the shooter would clearly be criminally liable, but in Florida, the law is different.
In New York, for instance, I would think that the law enforcement would view the victim as retreating. However, in Florida, there's a couple of things. There's the stand your ground law, and also the use of force doesn't necessarily have to be proportional to the perceived threat.
The legal question is whether the use of a gun is reasonable. It's a legal term often used, but hard for many juries to apply.
Law enforcement will first look at the reasonableness of the perception of the threat, the proportionality of the use of force, and finally, the totality of the defendant's actions. Was the defendant the initial aggressor? So, for instance, in this case, while the defendant started this entire situation by approaching the vehicle, the defendant was not the initial aggressor with the victim. Arguably, the victim was the initial aggressor because he pushed the defendant to the ground.
Then, Burkhalter says, comes the question about the defendant's state of mind. Understanding what he was thinking and what is seen in the video will give the jury much to consider.
The video, at the end of the day, is somewhat damning.
Attorney Sue Ann Robinson, who has appeared here on the Law&Crime Network, is familiar with the case and has worked with the law firm representing the victim's family.
If you recall, in the beginning, the defendant was not even arrested. They let him go. He slept that night in his bed very comfortably while Mr. McLaughlin was dead, and his family had to deal with that. So after getting over the initial shock of almost feeling like nothing was going to be done, I think now she feels like She has community support. She feels more empowered, and she's on the train of, justice might be slow in this case, but it is coming. Every day she tries to honor the legacy of her boyfriend, the father of her children, who lost his life essentially protecting them from a stranger. And so she does her best every day to just honor that legacy and teach her kids, her new baby and her smaller kids, keeping his memory alive. I think it's completely inappropriate for him to say it's self-defense. I think the real key and the thing that the prosecution has to try their best to bring out is that he was a gas station vigilante. He was at this gas station harassing people all the time. And there's records that show that the police had been out there previously to deal with him and him approaching people in the gas station. So to the extent that the prosecution can bring out that this was almost a pattern, I think his defense will kind of melt away for the jury.
With me tonight are attorneys Kirk Burkhalter himself and Michael Bryant. So Kirk, we heard your analysis in the piece there. You're here with us in person now. So what do you make of this? Is this guy the gas station vigilante? And even so, is it relevant enough to result in an outcome in this case?
Well, it may be relevant to the jury, and that's what's important here. And the prosecution will be able to introduce some evidence that he has committed certain acts similar to this, meaning chastising folks for where they park at the gas station. The jury is aware of this evidence. We talked about this earlier today. Prior bad acts are very, very effective with juries. If I can show that you acted a certain way previously, it's much easier for me to prove that you acted a certain way this time.
Exactly. That's that 404B evidence under the rules of evidence that you hear me harping about frequently.
Oh, yes,
Michael Bryant, because some states let more of it in than others, and it affects the outcomes, as you pointed out, Kirk, drastically. So with this case, I'm looking at that video, and I'm seeing what everybody else is seeing, and that is the man who became the victim here turning away from the shooter, and that, I think, is the most damaging fact for the defense.
On its face, yes. And I have to say, full disclosure, I hate when a non-handicap parking car parks in the handicap space. It chaps my hide. I just don't get it. Why do you think you're so special? Anyway, having said that, I think it's going to be more important to understand the reasonableness of the defendant when he had been shoved to the ground so violently. Maybe he would interpret the subsequent actions by the victim a little differently. Maybe he wouldn't feel like he was retreating. Maybe he was backing up to take another run at him. That's a possibility.
And Kirk, I think one of the big issues here is exactly who is the first aggressor. Is it the defendant for yelling about the parking spot? Is it the victim for then knocking the defendant to the ground? That line sometimes is easy to draw. In this instance, I think it's going to be tough.
In this instance, I think it will be a little tough for the jury because, well, let me say that the defendant was in a sympathetic situation in that he had children on the scene. I think if there were no children, his significant other wasn't there, the line would be a little bit clearer. I think if we just look at it on its face, there's really two things going on here. One is the defendant and his argument or confrontation with the woman in the car, and then his confrontation with the victim. If you just isolate those two, his confrontation with the victim, the defendant was not the initial aggressor here.
Exactly. We will have a lot to talk about when this case goes to trial next week. Meanwhile, the hearing today to determine just how much money a Florida defendant should have to pay after admitting he chopped up his own father's body. James Scandarito Jr. admitted detail after detail in court on the witness stand, but he beat the much more serious charge of murder. The prosecutor's office wanted him to reimburse $90,000 in police time spent trying to sort out exactly what happened before the defendant admitted to hacking up the body. But prosecutors said it was hard to parse out just how much money was spent investigating the alleged murder, for which the defendant was acquitted, and how much was spent on other police tasks related to the case, because we've got the dismemberment charge that stuck. This is how the defendant, Scandarito, testified during the actual trial.
Have you decided in your mind what you're going to have to do?
I have.
And what was that?
That I'm going to have to dismember my dad to be able to move him out of the house. So I had laid a clear tarp down the dolly was on top of the cart, on top of the tarp. And then I had another tarp that went over the top of the dolly and the plastic tarp that was underneath the dolly.
Okay. And so when you are actually cutting him, you're using what?
A saw.
And when you are actually cutting him, are you doing that underneath the top part?
Yes.
And why is that?
Because I can't look at what I'm doing. I just can't.
Okay, that was the testimony back during the trial. It sounds like he set up a miniature butcher shop in the house. So let's bring this one back to the panel. I'm sitting here watching those unanimous looks of bewilderment with both of you shaking your heads at the same time here. So the bottom line here is, how much should this guy have to pay? Because the police are running all over the place, remember, Michael, to try to find this guy. And remember, the defendant is saying, oh, he's probably just out having sex with his girlfriends. And meanwhile, now the defendant's admitting, oh, no, I had chopped them all up. Should he have to pay the whole $90,000?
It almost sounds like sour grapes to me on behalf of law enforcement, because the prosecution didn't win the day. I mean, to me, for Scandarito to get off on just chopping up his dad, as disgusting and despicable as that was, and as he was on the stand, prosecution had to see that day as a loss. So now, a la Jussie Smollett, let's go after the guy for the money it cost us to investigate. How do you cut it up? I don't know. Can they get it back? I'd say it's a loser.
I don't know. What do you think, Kirk?
Well, listen, this is coming from someone who was a cop for 20 years. I always considered that that was the job of law enforcement. So if we go around, we started getting, we being law enforcement, start being reimbursed for every false call and false claim and so forth. I mean, if the intent here is to dissuade folks from doing something similar to this in the future, fine. But how often does this particular instance come up? So
it's a bizarre one, and the bewildered looks will continue long after this case is done. I've got one more I want to ask you about before we head to the break here. A federal judge has held every single member of a U.S. attorney's office in contempt of court. The punishment came after a 3-year investigation into prosecutors who were recording and listening to prison phone calls between inmates and their attorneys. 3 criminal defendants have had sentences or indictments wiped clean due to the scandal, and now hundreds of others, at least 100 others, want the same thing done to their cases. One defense attorney said the tactic was like something out of the Soviet Union and not something he expected in this country with its guarantee of due process under the Constitution. So I'll ask you gentlemen about this one. Bottom line, prosecutors should not be listening to phone calls between defendants and their attorneys. Is this a good sanction? Just saying, everybody in this office, you're in contempt of court.
Well, in my opinion, the 4th, 5th, 6th Amendment, that's what separates us from many other countries. That's why there is some form of due process. That's why the police can't come and just kick down your door and search for evidence and can't listen to your phone calls and so forth. So I think that there is a very, very strong line there, and the government should know better.
Michael Bryan, I think we're on agreement on this
So
one.
egregious that I think it's best to go after everybody and effectively make them prove they didn't do it. Because maybe there were others that did not do it. But just blanket, whoever set this up, whoever allowed it to continue, let's go after everybody that was connected, and then we'll see if we can sort out a few that didn't do anything wrong.
You know, this involves the Office of the Federal Prosecutor there in Kansas, the big DOJ at the federal level, not really saying much about this one. But, you know, look, I mean, I worked out in that neck of the woods for a while. Bottom line, I agree with you, Kirk. We have a constitution here to protect people's rights, to protect everybody from intrusive government. And look, the government has to prove its case fairly. I'm all for that when there's a conviction that's fair.
Absolutely, absolutely. You know, that's what separates the government from what we used to always say, the bad guys, right? You do it right. And you have a job to do, but you do it right. And then if you don't do it right, there is no difference between the two parties. Then it's just crabs in a barrel.
Yeah, I mean, look at what the upshot of this could be. We could have 100 cases flipped because of this misconduct. Legally, that's the right outcome.
It is.
But boy, what a mess.
It's an overreach and it's unthinkable. What were they thinking? Come on.
Exactly. Okay, still ahead tonight here on The Debrief. A journalist's pursuit of the notorious Charles Manson leads to a new book and a new film. Plus, the effects of mass shootings on America's mental health. A new survey by psychologists suggests the problem runs deep. Welcome back to The Debrief. Let's check in with Brian Ross for a look at what's coming up on Brian Ross Investigates.
Thanks, Aaron. Coming up tonight on Brian Ross Investigates, in the wake of the death of Jeffrey Epstein, suicide or murder, tough questions for the Bureau of Prisons. Who's guarding the guards?
It should have never happened. It's shocking and disturbing.
Insiders describe chaos, corruption, incompetence, and cover-up. And before Epstein, there was Whitey Bulger, the infamous FBI informant murdered in a federal prison cell in West Virginia. 2 high-profile prisoners dead. FBI investigations and a federal prison system that hasn't had a full-time director for more than a year. That's tonight on Brian Ross Investigates, Aaron, right after the Daily Debrief.
We'll be watching, Brian. Thanks for that. And this month marks the 50th anniversary of the so-called Manson family murders. The notorious Charles Manson died in prison a couple of years ago, but the anniversary has resulted in a re-examination of the cases for which he was convicted. Filmmaker and author James Buddy Day wrote to Manson in prison before he died, and a new film and book highlight what Day believes went wrong with the Manson cases. Day spoke with me earlier today on the Law&Crime Network.
Ultimately, I think he was not morally innocent of the crimes. He was absolutely the catalyst for those murders. But I really do believe that the prosecution, the Los Angeles district attorney, fabricated a narrative in order to make his conduct criminal under the law. Back in 1969, they had this incredible problem. They had this movie star who had been killed, an incredibly famous case, a crazy public who was panic-stricken. And when they arrested Manson, they had to put him behind bars, but they couldn't find a way to legally convict him. So they did create this kind of false narrative that's become the Manson mythology. You have prosecutors who are noble in their intent, and detectives and police who are noble in their intent, but the evidence isn't always there. So you get scenarios where there's a noble conspiracy, where they create or fabricate a narrative in order to achieve a desirable goal. It's akin to planting drugs on a drug dealer.
The book and the film are out if you want to check them out. A new survey by the American Psychological Association says Americans are changing their habits due to a fear of mass shootings. Incidents these past few years in El Paso, Dayton, Parkland, and Las Vegas have led 1/3 of adults in this country to say they avoid certain places or events out of fear. The concerns are especially high among Hispanic adults. The survey aimed to study the stress mass shootings place on the mental health of Americans. According to the survey, 79% of Americans experience stress after a mass shooting. 32% worry about becoming a victim. 33% say they avoid certain places or events. Topping the list of places people avoid are public venues, shopping malls, schools, and colleges, and movie theaters. More than 2,000 people took part in that survey. A Florida jury this week deliberated for only 45 minutes in the case of a man who admitted killing his neighbor in broad daylight over a noise dispute. Joe Key was charged with first-degree murder in connection with the shooting of Edward Lee Tudor. Key took the stand in his own defense and claimed he was constantly bullied and harassed by the victim, ultimately leading him to take matters into his own hands. Here was the reading of the verdict.
State of Florida versus Q Key, indictment for count 1, murder in the first degree verdict. We, the jury, find as follows. The defendant is guilty of murder in the first degree as charged in the indictment. If and only if you find the defendant guilty of murder in the first degree, beyond a reasonable doubt, you must also find if the defendant did discharge a firearm causing the death of Edward Lee Tudor, the answer is yes.
And now to a verdict in the case of the so-called Hollywood Ripper in California, Michael Gargiulo, standing accused of a series of murders in California and also in Illinois. One of his California victims on the right-hand side of your screen, Michelle Murphy, survived the attack and testified against Gargiulo. Here's the verdict in this case, which came down yesterday.
Michael Gargiulo, guilty of the crime of attempted murder in violation of Penal Code Section 664/187A, a felony, who did unlawfully and intentionally attempt to murder Michelle Murphy. The defendant, Michael Gargiulo, guilty of the crime of first-degree murder in violation of Penal Code Section 187A, a felony, who did unlawfully and with malice aforethought murder Maria Bruno as charged in count 4 of the information. Michael Gargiulo, guilty of the crime of first-degree murder in violation of Penal Code Section 187A, a felony, who did unlawfully and with malice aforethought murder Ashley Ellerin as charged in count 6 of the information. This 14th day of August, 2019, jury number 10, foreperson.
Now let's check in with our panel one last time tonight on this case. Michael Bryant, let's get technical here. I'm going to reverse engineer this thing legally and try to figure out what's going on procedurally here. This sounds like a California dual plea. It was probably a not guilty plea on the core guilt or innocence, and then a concomitant not guilty by reason of insanity. That's why we're going to go into this sanity phase next week to try to figure out what else is going on underneath this. Does that make sense to you?
It's California, so you got to.
That's where you're licensed,
I know,
my
and
friend.
I said, those are my homies, place. But I don't agree with everything going on there. I think it's a problem, first of all, bringing in the Illinois case for purposes of tying the others together. I think that's a big problem because the jury has to somehow presume that you're guilty of that Illinois case, otherwise it's irrelevant in the California case. But they're told, no, this is just for identity purposes. This is just to show pattern.
Or plan. We're signature. Back to the 404B that I talked about.
Yeah, I think California is the most liberal as they can be on that front, and I just think it's unfair to the defense.
Kirk, what do you make of this here? We've got a sanity phase coming up next week. That's the defendant's burden in California. It's a preponderance of the evidence standard. So he basically has to try to convince the jury that it's more likely than not that he was criminally insane when he did this.
Very difficult standard to meet. He would either have to show that he didn't understand that his actions were wrong or the reasonableness of his actions and so forth. And here's somebody, I believe he worked and he had all these other things. So it's difficult to show that he was able to function in society outside of these particular acts that he's convicted of, function in society well and be insane.
I mean, there's evidence here of premeditation, I think. He's climbing up into places using like catwalks and pipes and things of that nature and going at it. So, hey, look, I think the insanity one's going to be tough as well, just as tough as the original phase of this case was. But listen, Kirk Burkhalter, the man with the law on the tip of his tongue, Michael Bryant, the man who's calling out his friends in California. He doesn't like that part of it. I appreciate your insight here on the Debrief. Thanks to those of you watching. Have a good weekend, everybody. We'll be back here at 5 o'clock Monday.